Thank you. Please be seated. Good morning. This is the time set for oral argument in State versus Christian Adair, our case number CR140115. Each side is allocated 20 minutes for their presentations. If the appellant wishes to reserve some time for rebuttal, you're free to do so, but you need to keep track of your own time. Out of respect for counsel, I would ask that everyone in attendance make sure their telephones are turned off so their presentations are not interrupted. We have reviewed the briefs. We've conferenced the case this morning. We also have given you some homework in advance of today with respect to some cases that we'd like to hear more about. We encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded. They will be posted to YouTube in due course, so please, as you begin your presentation, state your name and the party that you represent. With that, Ms. Martin, you may proceed.
Thank you. Oops, someone was taller than me. Lisa Marie Martin for the state of Arizona. The issues here today are what legal standard is required for the probation department to conduct a search of a probationer's residence when the probationer is on supervised probation and has agreed to a search term as part of the conditions of that probation, as part of his conditions of release. The state submits that the trial court got it wrong here, that there's no U.S. Supreme Court case and no Arizona case that actually requires reasonable suspicion. And the court said that reasonable suspicion was required and that wasn't met here. Whatever the standard was here, even if it was reasonable suspicion, the court also erred in its factual findings and the different prongs that it found as to why the search did not meet that legal sufficiency. I would first want to address, the court asked us to address United States versus Knights, and that was addressed in the state's opening brief. But what?
And counsel, I will.
I'm sorry.
For the benefit of both of you, we've asked that you keep in mind several cases, and as far as addressing them or tackling them one-on-one, we'll defer to your judgment on
Okay.
that. But we are interested in
Okay.
how those standards in those cases may apply.
All right. Well, I would briefly then talk about Griffin a little bit first, because Griffin came out first in 1987 from the United States Supreme Court, and Griffin was a search under a Wisconsin regulation that provided that a search could be made with or without a warrant, and the search was made by a probation officer. And Griffin applied a special needs beyond the needs of law enforcement test, the special needs of the law enforcement, or the probation system, to supervise probationers who have already committed crimes.
But counsel, the
Yes.
special needs test was sort of pushed aside in Knights and Sampson, was it not? It wasn't even relied on by the Supreme Court in the subsequent case law.
It wasn't relied on by those cases, but the court also said in those cases, because we use the special needs test in Griffin, we didn't need to reach whether the search was otherwise reasonable under the Fourth Amendment. And I still think that the special needs test would be applicable or could be used in a case like this where the search was.
Are you advocating that we would apply the special needs test here?
I'm saying that it's certainly available, and certainly some of the considerations in Griffin, which then were reflected in Knights, should be considered by this court, because I don't think that Griffin was completely thrown out, the special needs of the probation department and the probation system. You still see that, the need to supervise, the need to protect the public, the need to help rehabilitate people by watching over them, by supervising them, especially in cases of narcotics and drug offenses. And this is a case of, I think the court went into the totality of circumstances in Knights because it was a police search, although it was also, the police knew about the probation term and went in and said, well, he's consented to this probation term, so I'm going to go in and search. So I'm saying that it's available. The special needs test is available, and I don't think that it's completely thrown out, and that especially the needs of the probation system and whatever test is used have to be considered. And those were reflected in Knight's. So the Knight's case, we have the totality of the circumstances in terms of reasonableness. Now, Knight's itself, everyone agreed that there was reasonable suspicion. So the Knight's court didn't require reasonable suspicion. It said no more than reasonable suspicion. So reasonable suspicion was the ceiling, not the floor. And Knight's said specifically, we're not deciding whether there could be a suspicionless search based on this term, and we're not deciding if this term is complete consent, such as a total waiver of your Fourth Amendment rights.
So what does that mean for this case?
It means you're free. It means that it hasn't been decided by the United States Supreme Court, and it hasn't been decided by the Arizona Supreme Court. And I think you can look at Sampson, and as the courts asked us to look at I say Kings because
before you leave Knight's, I'd just like you to turn back to that for a second, because one of the things that, yes, the court looked at the totality of the circumstances, but also noted specifically that the probation search condition is a salient circumstance, part of the totality of the circumstances, I would presume that.
Yes.
An important part. How does that factor into this case? I guess to cut to the chase, what is the state's position as to what this particular search condition does in this case? What is its scope, its meaning, and what are you suggesting that the scope condition, the search condition in this case, brings the level down to a suspicionless search, that it reduces it down, the floor essentially, down to no suspicion required?
Okay, first let me just say what it says, which I know you say what it says, but I want to say what it says. In bold caps, I agree to the following as conditions of the suspension or the imposition or execution of sentence. And under law-abiding behavior, all in caps, I will submit to search and seizure of person and property by the APD, Adult Probation Department, without a search warrant. There's no restrictions on time or place. There is nothing in there about a police officer. The state's position is kind of like in Kings, just because it says without a search warrant, it doesn't say, but there must be reasonable suspicion, or imply that there must be reasonable suspicion. It's extremely broad. There's nothing in here saying that there has to be reasonable suspicion. It's saying with a warrant, without a search warrant, there's no restrictions on time or place. Will submit to a search and seizure of person and property. Is that a salient condition? Is that something that was clearly expressed? Yes. Does the defendant have to sign those conditions if he wants to go on probation? Yes. Does every probationer have those conditions? This is not in the record, except maybe inferentially, but the probation officer noted that he checked with the defendant's probation officer, Mr. Baca, to find out if he had the condition. So I was wondering to myself, does that mean that some people don't have the condition? And why are these called uniform conditions of probation if some people don't? And it's my understanding it could be crossed out.
Court can always interlineate that.
Right.
I mean, these are really orders of the court, right?
Right.
But didn't Arizona in the past use language that's somewhat different than this with respect to uniform conditions of probation? In other words, the cases that are identified in the briefs, at times local law will use things like, without cause or sort of more than what's in here. And I think one of the things that Judge Brown has asked is this a consent concept? Or is this a Fourth Amendment floor below which nothing can go? Or is it something else? And the cases, as I read them, aren't always pristine in delineating.
Correct. Your Honor, there was in the oral argument after the hearing on September 30th, the state did argue consent just in the form of saying the defendant agreed to this term, and then talked about the defendant agreed to this term. Was there ever an argument specifically about a complete waiver under Schneckloff? That argument wasn't made below. I'll be candid with you; it was not made below. But as a salient condition, there's consent and the unambiguous term and the unambiguous consent that the defendant does not have to accept. So the consent is part of that, and that's what lowers the defendant's expectation of privacy so much.
Is it that the consent is part of that in the sense that Appley was a probationer at the time, or is the consent part of that the specific term of the probation condition? In other words, is it the fact of, because the cases talk about the fact of a parolee, for example. Sampson is the best example of that. Right. That says parolees per se, have a lowered Fourth Amendment protection that is probably only exceeded by a prisoner, according to Sampson. And probationers and parolees, depending on which case you look at, are sometimes described differently. Now, whether they're treated differently, I'm not sure. And that's one of the reasons why we have oral argument today. But is it the fact of probation, or is it the terms of probation in determining a constitutional floor that matters?
Well, it's both. Because the probation system, the fact that the defendant's on probation, but that term, the defendant already is going to have lesser liberty, a lesser liberty interest because they're on probation. They are out on conditional release, even if they didn't have that term. But the fact that they have a term saying you can search me, without a warrant, with no restrictions on time or place, that makes their interest in privacy even less. That limits it even more significantly. So it's a double whammy for the probationer, and it is the term and both that makes their rights under the Fourth Amendment get lower and lower.
Counsel, is your argument pertain only to supervised probation, supervised probationers in the state of Arizona, or could it apply to unsupervised? I.e., get convicted. I'm convicted of shoplifting. I need to do 40 hours of community service. I'm on probation until I get that done. Can the police search my home?
Well, like I said,
without probable cause, without reasonable suspicion.
I think if you were on summary, unsupervised probation, and you had not signed something that your release was conditioned on these particular terms, I would say that you would not be able to go in and do a suspicionless search.
Understood. So the condition is a key. Appears to be quite key.
Very key and salient. But the fact that someone is on probation already, particularly supervised probation, as we have here, particularly for drug offenses, are something that is very important, and the cases do mention that.
I'd like to follow up on one more question about the conditions. Condition 7 under the label resident says, "I will provide the adult probation department safe, unrestricted access to my residence." And then it goes on. What is your opinion of the scope of that?
I have actually, and again, if I don't want to say things outside the record, but I have asked probation officers about that because there was something in the record about a prior probation officer doing a walkthrough. There was something in the September 30th hearing about, Rachel, I can't remember her last name, prior probation officer Rachel did a walkthrough in defendant's place, and she, it wasn't a search or whatever. And they said, walkthroughs are different than the searches. Basically, they were trying to say she didn't bring a bunch of police with her. And they said, walkthroughs are different than searches. It's basically the probation officer checking, do you still live at this address? And maybe if there were a bunch of drugs and paraphernalia laying out on the table. I mean, obviously that would lead to something, but they don't open drawers and, you know, they're not searching for contraband or anything like that. They're doing a walkthrough to kind of to verify the person's still living at that address.
Okay, thank you.
How do they verify that the person's living at the address without looking into closets and pulling out drawers, making sure that their clothes are there? And I mean, how do you do that without doing this?
Well, I guess I can't say exactly what they do, but that's my understanding. I mean, I suppose if there was, you know, no furniture in there, you know, and it had been like staged like one of those HGTV shows, you know, you'd kind of know that nobody was really living there. I mean, my house, you can tell someone's living in it. But, you know, presumably, you know, there's a car there. I mean, someone answers the door getting out of the shower. I mean, there's mailbox, whatever.
From the state's perspective, given the conditions that we've talked about, including the submit to search and seizure without a warrant and the Fourth Amendment, what is the floor? What is the bound? What is the limit on what a probation officer can and cannot do from the state's perspective?
Well, Your Honor, I think the limit should be, and I have my little test right here, that if the officer believes that this is necessary in the performance of their duties, and those duties are to foster the offender's rehabilitation and preserve the public safety. I mean, we have like drug testing, things for deterrence. I mean, say this defendant, whether we didn't even get the tip, we knew that he had sold drugs before. We knew that, say we know he hasn't gone out and looked for a job. I mean, this is a hypothetical, that he doesn't have any means of employment, but we find out he's throwing money around or he's wearing a bunch of new clothes. We might want to go in there and say, you know, where's this money coming from, even if we didn't get a tip? It's just things that the probation officers are experienced to look at and know to kind of keep these people in a straight line. And so the floor is that they need to have some leeway, but we need to have a workable uniform standard. And unless it's completely arbitrary or amounts to harassment, then they should be allowed to search based on this search term.
And what authority is that test based in? Where would we find that?
I think you could find it from, you could apply the Sampson test, which is even more broad than that. And that's why I still like the special needs test of Griffin, that you take in the special needs of the probation system and say, this is one of the places where, you know, we can't run around right now and say, well, are you, you know, we have to have reasonable suspicion to see if this person's selling drugs, even though they sold drugs before, and even though they're on probation. You know, we have to do all this surveillance and actually see him doing it, even though he's a convicted felon and he's probably hiding it, and he's making sure he's going to his probation officer every week like clockwork. So as far as the test, I mean, there may not be like an absolute one case that has the test. I do like the King case, excuse me. I mean, if you actually look at the earlier version of the King case that was vacated that shows the facts in that case, there was no reasonable suspicion at all. I mean, it was basically a comedy of how the police officer got information to follow up on this probationer. It was like somebody was standing at a homicide scene who talked to somebody else, and police officer listened on the phone and finally got an identity that this guy, you know, this defendant was on probation, and he was on the cover of a rap album. He hunts him down at his grandmother and mother's house. He finally gets there and finds a gun under the guy's bed. And originally the district court said there was no reasonable suspicion, and then the Ninth Circuit found there was no reasonable suspicion, but based on a case versus Baker, we're going to find that suspicionless searches are okay. Well, then they went back, that's the case that you told us to look at, and said, well, no, because Baker didn't really look at the distinction between parolees and probationers like Sampson did, and so we want to now see, even without reasonable suspicion, can we uphold this search?
And how does Sampson apply here? Sampson was a parolee, and you're right, the courts at least say and maybe in fact apply a distinction between parolees and probationers, but how, if at all, does Sampson apply to our task here?
I think that this court could adopt the Sampson test. I know Judge Orozco, and I'm really sorry about making an error in the reply brief. In the opening brief on page 25, I said the Court of Appeals decided Walker. You, in fact, wrote it. And in my reply brief, I said the Arizona Supreme Court decided it. But in Walker, Judge Orozco says likely the same standard is going to be adopted for probationers as in Sampson.
But
And there's
Walker
no
didn't-
reason why it couldn't be.
Walker didn't have to decide that.
Right, it
Because a
didn't.
reasonable
You-
suspicion was there.
Right.
And it, at least on the record that comes to us, the Superior Court made an express finding that it's not here. Right?
And yes, and and I have 55 seconds, but I certainly have a lot to say about that. But I want to answer your question first. And the question is, Sampson, you could still apply the Sampson rule because probationers, even though the Supreme Court said probationers and parolees are different, parolees are more like prisoners, they did not decide the issue of probationers. They did not decide that issue, and there is a significant, substantial limitation of a probationer's rights in Arizona. We have this condition of probation. It's extremely broad. We have a history of the cases that have found those, broad conditions constitutional in Arizona. We have nothing that's prohibiting you, from adopting the rule in Sampson. And I do object to the facts of the trial court. I'm sorry about that.
Thank you, counsel.
Okay.
Mr. Steinfeld.
Good morning. May it please the court, my name is Michael Steinfeld and I represent Mr. Adair. There's a very simple reason in this case why the trial court correctly ruled that the reasonable suspicion standard applies. It's because probationers, even with a search term, have an expectation of privacy that society would deem as legitimate. Parolees with that same search term do not have an expectation of privacy that society would deem as legitimate. That's the real juxtaposition between Griffin and Knights and Sampson. When you look at Griffin, the Supreme Court started with the premise that probationers have an expectation of privacy just like everyone else, but it's reduced. Now, the regulatory scheme that existed in Griffin operated as the functional equivalent of a search term. Then when confronted with the actual search term issue in Knights, the Supreme Court reiterated that probationers, even when they have a search term, have a reasonable expectation of privacy that society would deem as legitimate. The reason the court went through such painstaking efforts to differentiate between parolees and probationers and that search term in Sampson was because the Supreme Court reached a completely different decision. The Supreme Court reached the decision that in light of the parolee versus probationer status coupled with the search term, no person would deem a parolee's expectation of privacy as legitimate. When you have a legitimate privacy interest, there has to be something to protect it. When you don't have a legitimate privacy interest, there's nothing to protect. It's that juxtaposition which explains why some sort of standard needs to apply in this case. But a closer reading of Knights explains why reasonable suspicion is the appropriate standard in this case. Now, I agree with the state that the Supreme Court inartfully stated that no more than reasonable suspicion is required. But I think the context of the remainder of the paragraph is important. When you look at the next sentence, they said, the degree of individualized suspicion required of a search is a determination of when there is a sufficiently high probability that criminal conduct is occurring to make the intrusion on the individual's privacy interest reasonable. And they cited to Cortez. Cortez was only a reasonable suspicion case. It dealt with an immigration enforcement agent, and that enforcement agent had been investigating a coyote who had been transporting people, had developed reasonable suspicion that this coyote would work primarily on weekends and primarily on clear nights. So they came to the first weekend clear night of the year. It had been a couple weeks since the coyote had transported anyone, and they also knew of the particular checkpoint, or not checkpoint, but mile marker, at which this coyote would turn in and meet some sort of a car. It was mile marker 122. It was actually in Casa Grande. But so what happened in this case was the court looked only at the issue of reasonable suspicion. So while it inartfully stated no more than reasonable suspicion is required, the very next sentence referred to a case that required reasonable suspicion. You look further in the paragraph and you find the exact same thing. Although the Fourth Amendment ordinarily requires the degree of a probability embodied in the term probable cause, a lesser degree satisfies the Constitution when the balance of governmental and private interests makes such a standard reasonable. With citations to Terry, which we all know is a frisk and a reasonable suspicion case, and Brignone-Ponce, which was a roving immigration stop case. And what they found in Brignone-Ponce was that in order to justify a stop of a car on the grounds of immigration enforcement, there had to be at least a reasonable suspicion that there were undocumented aliens in that car. Every single case that the court cited to in the context of the paragraph required reasonable suspicion. So when we get to the conclusion of that paragraph and the court's statement, when an officer has a reasonable suspicion that a probationer subject to a search condition is engaged in criminal activity, there's enough likelihood that criminal conduct is occurring that an intrusion on the probationer's significantly diminished privacy interests is reasonable. The Supreme Court set forth both the ceiling and the floor at a singular point.
Let me ask, does that floor, if looking at it as a floor, does that turn on the terms of the probation grant here? In other words, is your client claiming that this wasn't authorized by the probation conditions, it's instead that it wasn't authorized by the Fourth Amendment?
I think that there's two claims to it, and I think that both would be coupled to a similar term. First and foremost, that it's not authorized by the Fourth Amendment, but even under the specific terms that he shall submit to a warrant, those terms don't authorize an absolutely suspicionless search. What it really does is it means that he can't slam the door in an officer's face if the officer comes without a warrant. All of us have the ability to look at an officer who comes without a warrant, laugh at them, and slam the door in their face. I used to have a little placemat that said, "Come back with a warrant," in front of my front door. He can't do that. He's not entitled to do that. But it doesn't mean that he waives the requirement that there be some modicum of proof. Otherwise, we would inherently get back into a Marbury versus Madison problem. He has a right.
Let me stop you just short of there. But how about in the analogous situation of drug testing? A probation officer can ask a probationer to drop on a whim. Mm-hmm. How does that influence what we're asked to decide?
Because it's actually a different scheme. It's a regulatory scheme. And the reason that there's that difference is actually explained in Griffin and in TLO. In Griffin, the Supreme Court addressed it as a special needs case in light of the fact that there was a regulatory scheme that authorized it. And then when you actually look in TLO in footnote 8, it indicates that individualized suspicion is typically required, but for those circumstances where there's a regulatory scheme. Now, that regulatory scheme has some sort of repetition and ongoing factor to it that avoids some sort of abuse. Really, that's the goal of those special needs.
Wouldn't that imply then that if through the code that probation officers are directed to comply with by the Supreme Court, that if the answer was you will then search a probationer's home once every 3 months, that would be just fine, even though you might not have any cause, suspicionless. But if you do it based on something that might be less than reasonable suspicion, that is prohibited by the Fourth Amendment?
I don't think that's an unfair distinction to draw. When you look at the Supreme Court's analysis of special needs, it constantly goes back to camera. And in camera, what happened was a fire investigator believed that there was a certain dilapidated area where there might have been concerns about fire risk. And what the Supreme Court held was that reasonable suspicion wasn't required, but instead what could be issued was called an area warrant. But ultimately, what the Supreme Court found was that because there was some sort of supervised mechanism that exists that avoids just personal discretion of the officer in the field, that actually guarantees or protects that privacy interest adequately. And I think that's where Griffin ends up going to. When Griffin says, we have also held that in certain circumstances, government investigators conducting searches pursuant to a regulatory scheme need not adhere to the usual warrant or probable cause requirements as long as their searches meet reasonable legislative or administrative standards. It's the need and the existence of those legislative or administrative standards to govern and remove any risk of absolute discretion of the officer in the field. And that's what TLO talked about, was removing and avoiding the discretion of the officer in the field. So I think Your Honor's proposal is actually a possibility that if the Supreme Court were to implement something that said, in a regulation that was published, you have to search a probationer with this search condition every 3 months, I think that removes the discretion, and that might be something that would be appropriate. I think that we would still reserve a Fourth Amendment argument, but from a special needs perspective, that would satisfy special needs.
Go ahead. Counsel, turning back to the condition, if the condition here were worded a little bit differently, somewhat akin to other states that are more aggressive, seemingly more aggressive in their approaches, what if it said without a search warrant or without cause, with or without cause whatsoever?
The fourth.
Do you agree that, or disagree that that floor can be reduced lower than reasonable suspicion based upon the actual wording of the clause?
I would say that the actual wording of the clause cannot reduce the Fourth Amendment floor, and I would use Knights as that example.
But before you go to Knights, maybe you're going to this, but footnote 6 specifically says, we do not decide whether the probation condition so diminished or completely eliminated Knight's reasonable expectation of privacy. How would you interpret that? They're saying we're not deciding that.
I think that's a fair point that they're saying they're not deciding. But I think what's also notable is that what they've done in that case is they've established that a right exists. And the only time that you can really get away from some sort of protection, there has to be some sort of protection, unless you completely remove the expectation of privacy. I think that's what the juxtaposition between Knights and Sampson ultimately gets to. I think what's also notable about Knights is that in Knights, there was a search condition that was worded more aggressively than in this case. In Knights, it actually said that there was no cause required. So from that perspective, I would actually agree with the dissent in King that the wording, to whatever extent the wording plays a difference in this case, it bolsters the expectation of privacy. But I would go even further than that in saying that because the wording in Knights specifically was more aggressive, and the Supreme Court still set forth what I'm interpreting as a floor at the very least, that the Supreme Court has at that point indicated that you can't go below reasonable suspicion even with these search terms.
No matter what.
With an exception. I think that the Griffin-type exception of special needs might circumvent that. And I think the reason for that is because, again, according to TLO and Griffin, it avoids the individualized discretion of the officer. And so if there was something...
But and I understand that, but that's different than whether someone has waived a constitutional right. I mean, I understand the sort of administrative function aspect, but that's really looking at this from a very different direction as opposed to what the probationer has waived or retained, depending on your perspective. But your position is, no matter what the probation term, a probationer, a warrantless search of a probationer or a probationer's home by a probation officer would always have to be supported by reasonable suspicion.
It is my position that it would always have to be warranted by reasonable suspicion unless there's that regulatory scheme, setting aside that regulatory scheme. And I think that the juxtaposition between the cases really does give that, because again, we get into a Marbury versus Madison problem otherwise. You have a right that has no remedy. Now that administrative procedure, that regulatory procedure can supplement in for that remedy. And so that's why special needs applies in those sort of regulatory schemes. But we have no evidence in this case of any sort of a regulatory scheme that exists. There was nothing testified to about that. And so in absence of that regulatory scheme and concrete proof that people complied with it, I think that's problematic. Now, beyond that, Your Honor, I think that what we end up getting into is a question of, ultimately we're talking about what's the appropriate standard. I think the error with the state standard is twofold. The first one is they're drawing from Griffin, which is that special needs case. We don't have a special needs case here, though, even under the words of Griffin and under TLO, because we don't have that regulatory scheme. I think the second problem with the state's analysis is that it's attempting to take Sampson and apply it to a case where Sampson really doesn't apply. Sampson deals with parolees for a very unique and distinct reason, which is that parolees with this condition do not have that right to privacy and thus don't need any protection of something. You compare
Is it
that.
that they have no right to privacy or that they have an extremely diminished right? Because I think there's a difference.
I would agree there's a difference, and I believe that I'm on the right side of that. If you look at Sampson, the ultimate conclusion was that parolees, because they're so similar to prisoners, so parolees who have that search condition have no expectation of privacy that society would deem as legitimate. You compare that with Knights and Griffin, and the starting point in both of those cases was that probationers have an expectation of privacy that society would deem as legitimate.
And clearly those cases say that treat probationers, or say they do, as having something more. But what they don't, I think, don't do is say exactly what that something more is. Mm-hmm. And that's what, in some respects, we're asked to decide.
And I agree with you that that is what we're asked to decide. I think the juxtaposition of the difference then is in the absence of a regulatory scheme that can step in and protect whatever that right to privacy is, there's no other legal standard but for reasonable suspicion. When you look at reasonable grounds, reasonable basis, it always ends up coming back to reasonable suspicion.
But let me ask, and Sampson is probably a good example of this, but it actually comes back to reasonableness based on a totality of the circumstances. And that, at times, is probable cause, for example. And at times the court has talked about reasonable suspicion. But that's not to say that what happens elsewhere couldn't be reasonable based on the totality of the circumstances, even if it met neither of those two standards.
I actually disagree with the court in that perspective, and the reason for that is if you look at TLO, the language that they focus on in distinguishing why in talking about individualized suspicion, they specifically note that individualized suspicion isn't always required, as Your Honor suggested, but that the exceptions for those times come in circumstances where there's a regulatory scheme. And so they cite, for example, camera, and indicate that that individualized suspicion wasn't necessary in camera. They also cite to a trio of cases, Berger, Donovan, and Biswell, that all went to highly regulated commercial industries. And so that searches in those highly regulated commercial industries don't require individualized suspicion. But in all four of those cases, you still had a regulatory scheme that existed. In absence of that regulatory scheme that steps in to avoid some sort of individualized discretion of the officer in the field, they noted that individualized suspicion, at least some modicum of individualized suspicion, is still required. And that individualized suspicion, the most reduced it's ever been in case law that I've found, is reasonable suspicion. Because when you compare TLO and O'Connor and their utilization of reasonable grounds or reasonable basis, it always still comes back to reasonable suspicion. So, for example, in O'Connor, it dealt with a hospital employee, a doctor, who had been suspended and they were investigating the doctor for violation of hospital policies. The Supreme Court held that reasonable grounds or reasonable basis to enter the office, where there was a reduced but legitimate expectation of privacy, was satisfied if there was reason to believe that evidence of the doctor's violation of the policies would be found inside the office. So it's a reasonable suspicion standard applied to an administrative setting. You also look at TLO, and you had a school setting. And in that circumstance, what happened was a teacher caught a girl smoking cigarettes in the restroom. Apparently, it wasn't against the law for the student to be smoking the cigarettes. Don't ask me how that happened. But it was a violation of the school policy to be smoking cigarettes in the lavatory. And so when the vice principal then searched the purse, the Supreme Court held that there was reason to believe that he would find evidence of the violation of school policy in the student's purse. But again, all it is reasonable suspicion applied to an administrative context. So reasonable suspicion, the synonyms that have been used at different points, haven't reduced the standard, but have merely applied the standard to different settings.
Let me ask you to address, and you've addressed, or mentioned at least the dissent, but the decision in King that came after Sampson and appeared to apply it to probationers.
I believe that Sampson erred in two fundamental constructs. The first fundamental construct...
Sampson or King?
I'm sorry, King. I apologize
Okay,
about that. That was my fault. I believe that King erred first and foremost in the fact that they did not recognize the difference and the fundamental difference between probationers and parolees. Ultimately, what they concluded was that a probationer has a right so reduced that there's no protection for that person. But inevitably, that's the problem with that is that it's not in accord with Knight's or any preceding case.
Did they say no protection?
They did say that there was some sort of protection, and that's where I think this court could interpret King still consistent with the trio of Griffin, Sampson, and Knight, which is they also focused on the fact that there was a regulatory scheme and that the regulatory scheme still allowed certain challenges. Now, whether or not that regulatory scheme was constitutionally adequate was not the subject of dispute in King. And I think that's notable because you compare it with Griffin, where the sufficiency of the statute or the regulatory scheme was the subject of dispute. Then it's a constitutional determination as to whether or not reasonable grounds, as articulated by the Wisconsin statute, was sufficient, as opposed to no purposes of harassment under the California statute in King's. So I think that to that extent, this court could still interpret it as being consistent on the grounds of special needs under Griffin. That doesn't apply in this case because there is no regulatory scheme. That being said, to the extent that this court might apply it and endorse it as being dispositive in this case, I still would disagree with the notion that you can reduce an expectation of privacy to such a degree that it exists but has no protection. I think there has to be a bright line put in there. And that's ultimately what overruling Barker did, was it noted there's a bright line between probationers and parolees. There's an expectation of privacy for probationers, but not for parolees under Sampson. To that extent, there has to be something in place to protect those individuals. And the most reduced it's ever gotten is down to reasonable suspicion.
Counsel, I'm going to give each side another 3 minutes, so you'll have a time for rebuttal and a fair opportunity to complete your remarks. Let's add that time on there. Counsel, please continue.
Thank you. I think the next, I'm sorry.
Yeah, I would just like to sort of digressing a bit, but in your answering brief, you had cited to the Arizona Constitution as suggesting that the Arizona Constitution, counterpart of the Fourth Amendment, provides a greater expectation of privacy for your client. I guess my question is, was that argument raised in any way below in the Superior Court?
It was not, but I don't believe that it has to, because in light of the fact that
and why not? I mean, isn't that a claim that you're making? You're basing it upon. It's a separate claim, is it not? Why wouldn't that have to be raised?
It's
below?
not a separate claim, because since we're the prevailing party, it's an alternative reason for affirming the judgment below. And so in light of that, I don't believe that it was necessary. But beyond that, I believe that the argument really goes to the notion of that expectation of privacy and whether or not society would deem it as legitimate in light of the fact that the Arizona Constitution and the Arizona Supreme Court under Alton Bolt have indicated that individuals in Arizona have a heightened expectation of privacy in their home. That would apply even to cases such as this, where we have probationers. And to that degree, would balance the expectation of privacy to some level. Would it balance it completely? Absolutely not. We're not up here saying that out of nowhere Mr. Adair is suddenly equated to an individual who's not on probation and does not have that search term. But it would at the very least render an expectation of privacy in the home to be even more reasonable than an expectation of privacy while out and about. I think, for example, if you took a less intrusive intrusion, say a frisk, then perhaps this court might be able to tolerate it in light of the combination between the Arizona Constitution and the United States Constitution, and say there's such a reduction that perhaps in a frisk there need not be any reasonable suspicion because he's conceding or there's that search term. But the problem is that because this is an imposition into the home, the most protected area that an individual has.
About a walk through the home, just walking through. I'm the probation officer. I knock on the door and I'd say, time for a walkthrough.
I think the walkthroughs pose an interesting issue, and I would point out that probably falls more in line with the special needs than it does with the circumstances of this case, in that it's less up to just the discretion of the probation officer, and my guess is there would be some level of guidance. Now, if there's no level of guidance, though, I would still assert that there needs to be some level of reasonable suspicion. But I still think that's still an intrusion into the household. You don't need to get into the drawers for it to be the most intrusive. You need to get into the house for it to be the most intrusive. And so without that reasonable suspicion, that heightened expectation of privacy in one's home, I think is still necessary. I would also argue and reiterate, as iterated in the answering brief, that there was sufficient basis for the trial court to make its ruling on the reasonable suspicion itself. As a result, we would request that this court affirm the trial court's ruling.
Thank you, Mr. Steinfeld. Ms. Martin, rebuttal.
Thank you for the 3 minutes. First, I want to just briefly address the Arizona Constitution claim, just to affirm it was not raised below, and it was brought up for the first time in the answering brief. And I don't think it doesn't change the state's argument, even though homes are very protected under Arizona law. I still think that looking at the probation cases.
But deciding an issue of this magnitude, why would we not, at least consider the Arizona Constitution that our Supreme Court has told us it carries great magnitude?
I was just affirming that it wasn't raised below. Obviously, it's up to you whether you consider it or not, and I think, it's something for you to look at, but I don't think it changes the analysis, because pretty much all of the cases that talk about the home as the castle doctrine in Arizona, none of them involve probationers. And this probationer is only in his castle, as a privilege for not being in the sheriff's castle, or the state's castle. So I also want to address where the defense says that if the probation department did a search every 3 months, that would be okay, because that would be, regulatory system that wouldn't allow discretion. Well, it would also turn the probation system on its head. Oh, I'm going to get another search in 3 months. Let me clean all the drugs out of my house and, give my friends all the guns. The whole purpose of the probation system is for supervision. If a defendant, a probationer knows that he's going to be searched like clockwork every 3 months, he's going to hide things. He's going to get them out of his house. That's the whole purpose, just like a drug test that a search could be when they're not expecting it. It's the whole purpose of deterrence.
But in this case, was it the defendant's probation officer that came by to visit, to do the search?
It was a probation officer that was...
Not his, though, right?
It was not his, but his was alerted to it. But
Doesn't that sort of cut against your argument that there's the special needs analysis, like that there's a regulatory scheme set up? Like, wouldn't the regulatory scheme be set up to support the notion that your assigned probation officer, yes, needs to be involved, needs to do the checking, but here it had nothing to do with the assigned probation officer?
Well, that's only because the defendant went to the assigned probation officer and was a good boy, and then the police called Richard Breed, who he had a relationship, and said, "I've got a tip from a non-anonymous citizen who says that this defendant at this address is selling drugs again," which is what he did before. And he took his child with him before, which, by the way, is nowhere in the public record before that he took his child. And so that's why the probation department went there, and the probation officer was informed. I'm sorry, I don't want to use up more than my 3 minutes.
Thank you.
That went by very quickly.
Thank you. Counsel, we appreciate your briefs. We appreciate your argument. You've given us much to think about. Thank you. We will take the matter under advisement. We'll issue a ruling in due course, written ruling in due course. We stand adjourned.
manage to say things in 3 minutes so much faster.
It's my old debate experience.
You talk
Once
very quickly.
I see a clock and I start talking too fast.
I'm supposed to be from the